My name is Dr. Ankita Gupta, and I'm going to be teaching you the law of contract. Over the next few lectures, we will be going through various concepts, principles, etc., pertaining to the law of contract, and this should help you in preparation for your various examinations. In the first session, we will be discussing the history, background, and need for development of the law of contract, along with the definition of contract, types of contract, and characteristics of contract. Class 2, 3, and 4, we will discuss the mode of formation of the contract, concept of acceptance, consideration, respectively. In class 5, I shall talk about the capacity to contract, and in class 6, we shall talk about the concept of free consent. In class 7, I shall be discussing the limitations that exist with respect to freedom of contract. And in classes 8, 9, and 10, we will be discussing the concept of performance and discharge of contract. Class 11 and 12, we will talk about the concept of breach of contract and remedies that are available for the same. In classes 13, 14, 15, we shall talk about the concept of agency, indemnity, and guarantee, respectively. And class 16, we will talk about the concept of quasi-contracts. Now, this is a very rough estimate of the structure with respect to the classes. There may be one or two here and there. During these classes, please note, I will also be taking you through some fundamental questions, MCQs, in order to help you give the right context with respect to your preparation. And for some, I will also be discussing some subjective type questions, which will help you in structuring the manner in which you study for your various examinations. Now, the overview for this particular lecture is that we will talk about the history or the historical perspective. We will talk about the nature of the law of contract, the extent and commencement of the statute, the types of contract. Now, when we look at the historical perspective, we find that the Indian Contract Act was created in the year 1872. And prior to that, in India, we only had the concept of personal laws or religious connotations or customary laws or customary methods which governed the modicum of entering into agreements between the different parties. Essentially, here I'm mentioning what the Hindus and the Muslims did. There are other religious texts as well, which I have not mentioned here. So, for instance, I have mentioned here the Vyavahara Mukhya, the Archasastra, Shrutis, Smritis, etc. Then here I would like to give an example which you may have already studied. For example, in the Hindu law, there is a concept of the son's pious obligation, which essentially means that a son is required to pay the debts which his father owed after the death of the father. Now, in modern contracts, you may find that the legal heirs or representatives of a certain individual have been written out of the contract and that they have nothing to do with the debts being paid for that individual. It is a possibility. In the Muslim law, for example, one of the teachings in the Muslim law says that taking interest on money is unacceptable according to some schools in the Muslim law. Whereas in the law of contract, there may be a possibility where interest may be earned in case there is a delay in the agreement or performance of the contract. So here one would find that a legitimate clause which would be by way of a penalty over the other individual would be written out of the contract. Why? Because it is against the religious or the customary tenets of this religion. So when the Britishers came in, you are aware of it, that the Britishers had economic interest for coming into India. And for economic interest, they were entering into various agreements left, right, and center, in order to ensure that the agreements that they entered into were enforceable and the rights and liabilities were realized under those agreements that were entered into. There was a felt need that the law of contract needs to be codified. Now, the East India Company, or the Britishers today, as we would call them, came from a common law country where, even though the principles were not codified, the jurisprudence surrounding the law of contract was very strong. And therefore, in the Third Law Commission, it was felt that the time is right in order to introduce a codified law of contract, which essentially was the compilation of various common law principles, precedents, and the jurisprudential principles that had been formed over the years, which form the basis of the law of contracts. Now, the statute was essentially drafted by Sir Fitz James Stephen in the year, and the Indian Contract Act was enacted in the year 1872. The Indian Contract Act was, to be very precise, it was enacted on 1st of September 1872. These dates are important because sometimes in MCQs you will find that some very specific questions pertaining to this historical data, which is very simple, but not very few people are able to remember. So it may be a good idea to remember it. Now, please note that the Indian Contract Act, it is the law that deals with the regulation of the rights of parties while entering into mutually acceptable agreements. The Contract Act provides for the contours or the framework within which the parties, the legal entities, are allowed to enter into agreements or contracts for themselves. When we are looking at the law of contract, it is worthwhile to note that it forms a part of our daily lives, our daily routines. We enter into numerous agreements and contracts almost on a daily basis. For example, the newspaper person who's delivering the newspaper to us is in a continuous agreement with us to deliver the newspaper for an entire month, for which he takes a certain delivery fee, but now it has been subsumed in the cost of the newspaper. Similarly, a lot of you will be taking help from Swiggy, Zomato. So, for example, Swiggy, Zomato, the Swiggy Instamart example. It is an example where you are entering into an agreement with a portal, a machine, but it essentially working on the same principle the way a normal contract would work, that you want a product, you identify it on the app, you order for it, either you pay for it there and then. So you are prepaying for it, and then the product gets delivered to your home or to your office space. Or you say, no, I want to do a cash on delivery. So somebody will come with that product, deliver it to you, and it will not be delivered till you make the payment. So this is a contract. You wanted a certain product, a certain good for which you have paid the money, but here you have done it without the interruption or without the interaction with a human being. Now, here we also have examples where services are provided in this manner. For example, many of you would be aware of the manner in which Urban Company, Urban Ladder are providing services, for example, the AC cleaning services. So you book it on your app, somebody will come to your house and they're going to then perform the service and you're going to pay for them. What is that? That's essentially a contract. Now here, if you're looking at the basic principle of the contract, let me take you through how the fundamental principle would work or the traditional concept would work, and which will help us remind us of the various principles that are actually associated with it. So for example, I want to get a dress made. I go to a tailor. Now, if I go to a tailor and I say, please make a dress for me, the first thing that the tailor is going to say is, please give me fabric. So I get the fabric, I give it to the tailor and I say, please make a dress for me. And these are certain conditions. I want it in this particular length. I want it to have these things. I want to have these kinds of buttons or this kind of neck or this kind of arm. And I want it for this particular purpose. And I want it within a certain stipulated time, 10 days from now, probably, or 15 days from now. The tailor is going to be taking money from me in order to create the dress based on the specifications that I've provided and using his expertise in order to ensure that whatever I've asked for could be created. The money that I'm paying to the tailor is not just to create the dress, but to use their own expertise as a tailor to create that dress. I know it's a slightly funny example, but if the tailor fails to do so, if the tailor fails to use their expertise and say, no, madam, no, madam, you had said that this thing, so I've made the product the way you have asked me to do. I have not used my expertise. But you realize that the dress is not wearable. Is the contract created? Has the contract been realized? I would not say that it has been realized. Similarly, from the tailor's end, there has been a certain breach because of which today we can say that the contract has not been made. However, there can be a scenario where the fabric that I have taken, the piece of cloth that I have taken to the tailor, that piece of cloth is either not enough or has some damage in it. And therefore, the tailor is unable to complete the contract that he has entered into, which is for no fault of his. But at the end of the day, the bottom line is that the agreement has not been fulfilled. The contract has not been fulfilled. Now here, who is going to be entitled to a compensation is what is going to be defined or is something that is defined by the law of contract. If it was my mistake because of the fabric was wrong or the fabric was torn or damaged, it's not the tailor's fault. And therefore, I, as an individual, will not be entitled to any compensation and, in fact, not even be entitled to take the remaining cloth back. However, if the product has not been created, if the dress has not been created by the tailor for whatever reasons, without giving any proper justification for the same or an acceptable justification for the same, I can ask for a compensation from the tailor. I can say that no, you have breached the agreement, you have not done your part, and therefore I am entitled to a compensation and that I will not pay you for the dress that I had promised. So this essentially becomes the manner in which your law of contract functions. Now, having said this, I would like to take you through the scheme of the Indian Contract Act very, very briefly. Now, Indian Contract Act originally has been identified in three parts: Part A, Part B, Part C, where Section A or Part A deals with the general principles of the contract, Sections 1 to 75. Then you have Part B, which deals with concepts of agency, bailment, hypothecation, etc., which is dealt with under Sections 124 to 224 or 225. And then you have a Part C, which deals with concepts of partnership, sale of goods, etc. Now, in 1930, it was the Partnership Act that was removed from your original law of contract, and it was created into a different contract. Similarly, the sale of goods was removed from the law of contract and created as a different statute. These decisions have essentially been taken with respect to ensuring a certain flexibility in terms of operations of the law of contract. What we are dealing with is the general principles under Part A and certain principles as laid down under Part B. Now, the law of contract is the most important branch of the mercantile law, and without which law, it would be difficult to carry on any trade or business in a smooth manner. The law of contract is applicable not only to businesses, but also to all day-to-day businesses and dealings, as I have just mentioned. The term business law also refers to those rules which govern and regulate business transactions. These rules and regulations, etc., bring a sense of seriousness and definiteness to the business dealings. The Indian Contract Act, like I have told you, came into effect on 1st of September 1872 and continues to be one of the oldest surviving legislations in India, especially after the CRPC, IPC, the Law of Evidence have been amended. This continues to be one of the oldest statutes which are still relevant and continuing. And they were post independence. They received assent from the parliament and to continue as a going statute in India. Here now, when we look at the Indian Contract Act, I want to say that it holds significant relevance even in today's era with respect to all the business transactions. And considering today that the business transactions are not only increasing by the day, but that now individuals, people who are manning various, even the legal entities, have now understood the importance of law of contract, and therefore they are now more inclined to enter into more and more different contracts. For every single transaction, now the oral concept of the fact that I have promised you that I will do this no longer exists. For everything, now there is a need that a contract should be in writing. If an agreement has been entered into between the two parties, let it be put in writing. Its enforceability will be checked later. But the fact that now people want to document the relationship between the two, that sort of signifies the growing relevance of the law of contract. For example, prenuptial agreements are not acceptable in India. In fact, even according to the law of contract, they are not acceptable in India. However, people are still entering into those agreements with full knowledge that they will not be upheld in the court of law, only with the idea that both the parties are documenting their rights and liabilities in a manner that tomorrow, should a problem arise, they will know how to resolve the dispute that they have between them. It will have a certain persuasive value. Now, from a very, very lawyer perspective, I can say that the growing significance of law of contract is essentially extremely good for a lot of employment as a lawyer, because this means that more agreements being signed, that means more work for the lawyers. Now, from this discussion, it is clear that contractual rights are rights in person. When I say that it is a right in persona, what I essentially mean is that it is essentially the two individuals or the number of individuals who have agreed to enter into an agreement that these rights and obligations can be enforced against them. Any agreement or contract that is entered into, it does not have any rights and obligations that can be enforced against the world at large. No, it cannot happen like that. And therefore, it is not a right in rem. That is a right. A right in rem essentially means that a right against the world, but it means a right, but that the law of contract is right in persona. That is, it is against that a right against each of the persons who are involved in drafting of the contract. And this is extremely important distinction to understand, because a right in rem would be a contract law or tort law where the state decides, okay, that an individual has a right against the society, against the public, against the world at large in order to protect their own right to, let's say, life, in order to protect their own body from injury from a third person who may be a complete stranger to the individual that we're referring to. Now, when I start with the law of contract, a very brief overview is something that I would like to give you. The law of contract is essentially, when you look at the law of contract, the first concepts that we look at from sections 1 to 10 are the methods in which the contract gets formed, the manner in which the contract gets formed. So there are certain basic principles. When is it that we say that an agreement is being formed? When is it that we say that the agreement enforceable by law becomes the contract? What are the various ingredients that must exist in order for the contract to be formed? So there should be free consent. There should be there should be legality of operations. There should be some consideration. The parties to the contract must be competent. There should be free consent. That means there's no undue influence, there's no coercion, etc. So here, the first idea is to understand whether the contract has been formed or not. And then we say, okay, the contract has been formed. We move over to the next stage where we say, okay, once the contract has been formed, now the contract has matured, and so the agreement has matured into a contract, and now we are awaiting for the performance of the contract. Once the terms of the contract have been performed by the parties, that contract dies a natural death. It dies a natural death. That means the terms and the conditions or the rights and obligations which in the contract have been realized, and therefore the contract no longer remains. It is over and done with. However, there are certain exceptions that come in where the terms of the contract may be breached. For example, the tailor example that I gave a little while ago, you find that for no fault of anybody, but because of the damaged fabric, the contract cannot be performed. The dog contract cannot be completed. So there's a certain breach that has happened. And that breach is because of impossibility of the conditions. Because of a damaged product, I cannot perform the terms of the agreement. Now, when we are saying that these breaches has happened, we then have to look at the remedies that both the parties have to be given. At the end of the day, there were two parties who entered into an agreement saying that I want something out of this agreement. But what is it that they're saying? At the end of if there is a breach, they realize that no, they're not able to get what they wanted. And therefore, the Indian Contract Act also provides for terms and conditions where a breach can be remedied. So here, when you look at the Indian Contract Act, I would say that we can sort of compare the law of contract, the manner in which the law of contract has been drafted, similar to the birth and death and growth of a living organism. Formation, that there is birth. Maturity, that now the parties are willing and able to perform the contract. So the individual, the child that has been born, grows up to complete all their life's obligations, enjoy the rights that have been given to them. And once their purpose on earth is complete, they would perish. They would die a natural death. There may be a possibility that they may die not of a natural death, but because of certain conditions beyond their control. In that, for example, an accident, a road accident. In that case, there may be a certain remedy by way of compensation that is being given to the individual. Correct? So this is what the overview of the Indian Contract Act is. And if you were to understand it this way, you will realize that it is very easy to remember the various terms. So like I said, there's formation of the contract, there's performance of the contract, and then there are breaches and remedies which are required. And this is something that you must always keep in mind. The next is the extent and application, or the extent and commencement of the law of contract. According to Section 1, the Act extends to whole of India, and it has come to force on 1st of September 1872. It is worthwhile to note that there have been no exceptions with respect to the application of the law of contract. And therefore, there were various exceptions that had been carved out for various other statutes. So this sort of tells us that the commercial aspect with respect to the application of the law of contract is going to remain the same. Now we move to the various definitions or the concepts of the law of contract. When we look at the law of contract, I would first like to talk about the Latin term contractus. It means to work on contract. And the law of contract has essentially been derived from the term contractors to mean that in mercantile or business laws, we are working on a contract. Here, so there have been certain reports which say that no, actually, the law of contract depends on the international law term pacta sunt servanda, which means that the agreements have to be kept, pacts have to be honored. If you have read the international law, where specifically the international law of the sea, where there are these various cases where ships are moving between one state to the other, I'm not going to name all of them because it will lead to unnecessary confusion. You will find that the states were asked to honor the pacts that they had entered into with the other state, which meant no piracy was permitted, which meant that if a safe passage had been provided, the agreement between the two states that the safe passage is being provided should be honored. And this is essentially the fundamental aspect pertaining to the law of contract, that if you have made a promise, you're going to ensure that that promise has been upheld, has been realized, and has been honored. Before I go to specific definitions pertaining to the various the various definitions pertaining to the law of contract, I want to mention Anson's principles of law of contract. Now, Anson has been one of the most read and jurist, and he has been one of the most foremost persons who have written extensively on the jurisprudence of law of contract. Not reading Anson's laws, Anson's principles on law of contract would actually mean a little bit of lacking on your part in terms of preparation for the various exams. So what Anson says is that a legally binding agreement between two or more persons by which rights are acquired by one or more to acts of forbearance on parts of others. So, according to him, the law of contract is that it is a binding agreement between two or more persons. So, we are looking at individuals or we are looking at legal entities, because persons in today's scenario mean legal entities as well. Now, here they are either agreeing to do something or forbearance on others to not do something. You either say that I will do something, or you forbid somebody else to not do something. That is also the law of contract. It is not always doing, but to abstain from doing something, that, okay, I am not going to attack your ship. That is also a law of contract. That is also a principle of contract, like I just talked to you in terms of pacta sunt servanda. The law of contract is intended to ensure that what a man has led to expect shall come to pass, and what has been promised shall be performed. So, if even orally I have given you an indication that I am going to not attack your ship when it enters my water space, I am going to have to abide by it, even if it is not written. But if I have indicated, I have led you to believe that no, I am going to protect your ships, or at least I'm not going to attack your ships. That is an agreement that I must adhere to. The law of contract does not lay down the rights and the duties, but it consists of limiting principles subject to which the parties may create rights and duties for themselves, which the law will uphold. So if there are parties which have said, I will not do this or I will do this, and they are generally within the meaning of the law. For example, if they are not doing anything illegal, that, for instance, creating a brothel, it's an illegal activity. So even if I enter into an agreement saying I will or I will not do that, that will have absolutely no bearing, because the law will not uphold such a thing, as it is illegal. So what the law of contract does is that it lays down principles on the basis of which the parties may enter into agreements, and that they have to be within the various principles that have been framed, like I said, free consent, legality, etc. And here we need to make sure to understand that parties are making the contract the law for themselves. It is a right in person. Various definitions, for example, P.S. Sathya, he says that a contract is a promise or a set of promises for the breach of which law gives remedy or performance of which in some way recognizes a duty. Like I just mentioned earlier, that if there is a breach that happens, because the party has lost something, because the party which was supposed to have got both the parties, for example, if it's a two-party agreement, if there is a breach, one party has committed the breach, which means that the rights of the other parties have not been duly fulfilled. The rights of the other party have been breached. And therefore, the law is saying that because there is a breach, there is a certain remedy that is available, and that remedy could be in the form of certain compensation. And as we will see subsequently, it could also be that the court will have the power to tell the breaching party to tell them that no, you must complete the agreement, because if you do not adhere to the terms of the agreement, the other party is going to suffer a substantial harm, which is not going to be fulfilled, which cannot be rectified by a mere compensation. So the law is recognizing a duty that if I have entered into an agreement, I cannot go back on my word. I cannot say, no, now I'm no longer going to perform the agreement. Then Section 2H of the Indian Contract Act says that an agreement enforceable by law is a contract. Now, I find this is the most beautiful and the most simplest definition, where an agreement is essentially the promise and the proposal between the two parties, as I will be taking you through later, and something that the law is going to enforce, that essentially becomes a contract. Next, Savigny. Savigny, with his historical perspective, says that a contract is the concurrence of several persons in declaration of intention whereby their legal relations are determined. So what Savigny is saying is that there are not just one or two, but there are several persons who have given their intention, which means they're talking in terms of consent. They're talking in terms of their mental state of mind. And then they are saying that they're declaring their intention. And then on the basis of that, they're creating a legal relationship. So if you were to read Athia's definition and Savigny's definition, in Athia's definition, you say that a promise has been made, but it is not talking in terms of the intention of the party. Savigny says no. We must also adhere to the intention because it may or may not have been written. And this is in line with what Anson has said, that if I have indicated that I'm going to do something or not going to do something, whereby the other party has acted, that means I must hold good to the indicative promise that I have made. And this takes me to the next definition, where Pollock says that a contract is a promise or a set of promises which the law is going to enforce. This is in line with Athia, but Pollock stops one step backward, wherein he is not even talking in terms of a duty. He says, no, if you've made a promise, it has to be enforced. It has to be adhered to. Salvin, being the clinical jurist that he was, he says that agreement creating and defining obligations between the parties. He is not talking in terms of the flowery language that, okay, there is a promise, there is an intention. No. He is saying if there are two or more parties who have sat down, because parties plural, if they have sat down and they have said that no, we agree to do this or we do not agree to do this, whereby each of the parties have obligations getting made towards them, then that is a valid contract. You are creating obligations between them. You're not creating rights. So as an individual, when I enter into an agreement with you, I am creating an obligation on you. You are creating an obligation on me. Salmon is not talking in terms of the rights that I get or the rights that you get because you are entering into this agreement. and which is a very, very strong definition, considering that in today's era, when people are trying to enter into agreements, they are not doing it so much for protecting their own rights, but they are doing so in order to ensure that the obligations that have been placed on the other person or the other entity are not violated, that the other party stands true to the obligations that they have entered into. And this is sort of fitting when it comes to the prenuptial agreements that I had mentioned a few moments ago. Halsbury's Laws of England, I'm sure all of you know about it. So, Halsbury's Laws of England is basically codification of, not exactly codification, but the encyclopedia which mentions all the jurisprudential principles that have been introduced by way of precedent, discussions, ratio decidendi by the courts at different levels. So, according to Halsbury, a contract is an agreement between two or more persons which is intended to be enforceable at law and is contracted by the acceptance by one party of an offer made to him by the other party to do or to abstain from doing an act. Now, this definition that Halsbury's laws have given is the most cogent, most precise, and the most concise definition of the law of contract that one could have asked for. This mentions what Anson says, this mentions what Savigny says, this mentions what Salmon says. And this you will find is also forming the foundation of the manner in which the law of contract has been defined within the statute. Now here, I would like to mention that to consummate a contract, there must be mutuality and meeting of minds. That is, so mutuality is essentially equality of rights between the parties. That is, any of the parties to the contract must have equal rights to enforce the contract. One party cannot have an upper hand in enforcing the contract while the other is only being, let's say, tagged along in the agreement. Both the parties should have a right to withdraw from the agreement with equal rights. And that is what the concept of mutuality is. Second is meeting of minds, which the formal term for that would be consensus ad idem. This implies that the parties have agreed to the same terms, have understood the implications of the terms in the same manner. There's a very common example that we refer to in the law of contract, wherein party A tells party B that I am going to be selling my white mode of transport to you. A is telling B that I will sell my white mode of transport to you. What B does not know is that A owns a white horse, a white minivan, a white car, and a white truck. What B is anticipating is that he would be sold a white car because that is what B wanted. But what A wanted to sell was a white horse. Now, here in this illustration, you find that both A and B are referring to different objects which fall within the same umbrella of mode of transportation. And therefore, there is no consensus, there is no meeting of minds between the parties with respect to the agreement or the substantial object of the agreement that we are looking at. Here, mutuality, if I were to take this example itself, mutuality here would mean that in case A says that no, I have decided I'm going to be selling you my white mode of transport and I will do that tomorrow. So you must get the money tomorrow. B says you have just told me that you want to sell it to me tomorrow. I don't have the money today and I need you to give me some time. So A says no. If you don't get the money tomorrow, the deal is off. Here, A is having more rights over party B because party B is now feeling extremely constricted and is under pressure to arrange for money tomorrow. This could be because party B has certain specific requirements to have that specific mode of transportation, or that it is simply it has lesser power in terms of party A. Mutuality would mean that both the parties should have equal right to decide when they would want the transaction to be completed. If party B says, no, I will do it in next 15 days, and A says, look, I need to sell this off next 15 days, I have to travel, let's try and do it in next 7 days if it's okay. And party B says, okay, next 7 days is okay. It's like a negotiation that has taken place. But both the parties have done it on an equal footing with mutuality of rights, equality of rights, and therefore this agreement would be acceptable. Of course, once the specification happens that it's a car or a horse, but equality is there, and therefore it would be an acceptable form of agreement, right? So another example that we can look at is that A wants to sell his box of apples for 1,000. B understood it as an Apple Watch, and while A was referring to box of apples. So I will sell my box of apples at 1,000. B accepted saying, I will accept box of apples at 1,000. Now this is consensus item. If they had not specified it, then there would not be a meeting of minds. Now let's look at the nature of contractual obligations. First, promises have to be honored. If you have made a promise, you need to perform it. This is something I've already discussed. Creation of rights and obligations. The law of contract, while it is not laying down the numbers that these are 1, 2, 3, 4, 5, these are the rights, 1, 2, 3, 4, 5, these are the obligations. It is only laying down what are the principles within which the rights and obligations can be met. So the party has a right to, the party has a right to consideration. The obligation is that if you have promised, you will not breach it and you will perform the contract. So thirdly, the parties are making the law for themselves. Then parties have the freedom to settle all the terms of their contract subject to only overall control of the law. There is no imposition. Okay, so there should not be any undue influence, no fraud, no coercion. Terms of the contract are reasonable and that they are not opposed to public policy. There is mutuality as well as consensus at item. There is law of precedence and self-imposed obligations. So the essential conditions of a valid contract would always must include our intention to create a legal obligation, offer and an acceptance, existence of consideration, consent of the parties competent to enter into a contract, lawful object, terms not being vague but terms being actually very specific. Terms must be capable of performance. It should not be that an agreement has been entered into saying, I'm going to find treasure by way of magic. This is a term that is not capable of performance. Legal formalities pertaining to the contract must be fulfilled. So, for example, if the law states that you are entering into a rent agreement with somebody, the agreement is not complete till that rent agreement is deposited with the specific office in that state, you cannot say that a valid contract has been entered into. And the terms must not have been declared void, which essentially means that the law should not have suddenly decided that we no longer want to agree to this particular concept. For example, if India is at war India is having peaceful relations with a country, suddenly India declares war with that country. Now, whatever economic relations between that country and India existed, the traders in India will have to abide by what the government of India is saying, because declaring a war with the country means that there cannot be any economic, any social ties, which will mean that the terms have now become void. Correct? So, when we say that the intention to create the legal obligation should be there, there's a very beautiful statement that has been made which says contracts must not become sports of idle hour, mere matters of pleasantry and badinage, never intended by the parties to have serious effect whatsoever. Now, when we look at a statement like this, it means that I cannot sue somebody for not taking me out to dinner. For example, two friends are sitting together and they are talking. And they say, okay, let's go out for, one says, okay, let's go out for dinner today. And in the evening, this person turns up and says, look, we can't go because I have some other work. Now, here, if you were to say, you created a legal obligation and that by not taking me out to dinner, it's a major, major violation of my rights, the court is not going to accept it because it's a simple, mere matter of pleasantry, where the parties did not have the intention to create a legal obligation. Right? So it's not that every casual conversation can be turned into a contract. And therefore, objectivity but within the contract, the objectivity within that discussion with respect to the intention to create the legal obligation must be sort of looked at before taking a decision whether or not that whether or not that conversation can be construed to have created a legal obligation. Now, here I would like to take you through some cases. These are extremely old cases, but they are the cases that have laid down the foundation of when one can say that a contract has been made. So, Balfour versus Balfour. This is a case where essentially uh, the discussion was between a husband and a wife. Now, the parties were married in England, and the husband was then posted to Ceylon. The wife accompanied him, but then she developed various health issues, so she had to return back. Now, when she was returning back, the husband had promised to send £30 per month for her daily expenses. So, subsequently, the husband, he stopped making those payments, and the woman was not allowed to travel undertake any strenuous journey as was advised by her doctor in England. Now, when the maintenance money fell into arrears, the woman brought an action against the husband to cover for those arrears, to recover those arrears. Now, here Lord Atkin, he made a very interesting statement. He said that there was actually no discussion in terms of between the parties in terms of specificity with respect to £30. Because as per the facts and as per various documents and evidences that were produced, the husband was able to prove that essentially £34 were demanded, but the expenses of the woman were £22, and he's made this statement. And then they said that probably a round figure of £30. So here we have the promise. I will make this payment to you. There is a consideration of £30. There is a competent, both the parties are competent, and it's a lawful object. Maintaining the wife by the husband is not an unlawful object. However, the intention between the parties to create those legal obligations upon themselves were not there. That intention was not there. There was no meeting of minds also. And it seems that at the end of it, it was the woman, the manner in which the woman brought forward the case, Lord Atkin was not convinced that there was a proper agreement or a contract that was entered into. And therefore, it was held that this is just a discussion that has taken place, but it is not a contract, and therefore it cannot be enforced legally by the court. The next case that I want to discuss is McGregor versus McGregor. It's an 1888 Queen's Bench division. Now here there was a slight difference. Again, it's a dispute between the husband and the wife. But here there is a slight difference in the manner in which this case was dealt with. Now here the husband and the wife were actually fighting with each other. Okay, their marriage was essentially on the rocks. And the wife went about pledging her husband's credit, because as you can see the timeline, that this belonged to an era where women, wives of the men, were allowed to pledge the credit of their husbands. So the wife went about pledging credit of the husband, and then there were complaints that have been made against each other by both husband and the wife. So the agreement that was reached into between both the parties was that they would withdraw complaints against each other, they would stop, and that the wife would stop pledging his credit, and the husband would pay a certain allowance to the wife. This agreement was held to be a binding contract. Why one would say that this was held to be a binding contract? Because both the husband and the wife were able to prove that their specific actions, for example, withdrawing of complaint or refraining from pledging the credit, they had very specific connotations in terms of the agreement that was entered into between the two. And that it was not just a dinner table conversation that, okay, fine, I will give you £20 a month, or I will give you £30 a month. There's a huge difference between the Balfour versus Balfour and McGregor versus McGregor case. And therefore, in the case of McGregor versus McGregor, the court said that this is a binding agreement between the parties and that the law can enforce the rights and obligations that have been mentioned in this agreement. The next case that I want to mention is Jones versus Parvata. It's a 1969 All England Reporter judgment. It is a case in which a mother convinced her divorced daughter, mother of a boy, to give up a lucrative job in Washington and come to London, go to London, study law, and settle down in Trinidad. Now, in this particular case, the daughter left the job. She got the admission to study law in London. And while in this particular time, the mother is paying the college tuition fee. She has arranged a house in the London, and she has arranged a house in London. Now, the daughter has failed to complete the course even after completion of 5 years. Not only that the daughter has failed to complete the course in course of 5 years, during the meantime, she has also remarried. Now, here the mother wants to repudiate the contract. The question that was asked was that if mother repudiates the contract, if mother withdraws from the contract, is she breaching the contract? Or has the daughter, by not completing the course that she was supposed to complete, but while staying in London in a span of 5 years, that she is not able to complete, and that she has remarried without the consent of the mother, did the daughter breach the agreement before the mother repudiated the contract? Here, if you were to look at the facts and circumstances, the course of law, 5 years law course, has only come into being now. Otherwise, it has always been a 3 years course, whether in London, England, or anywhere else. So this essentially means that the mother felt that the daughter is going to be able to complete the course, if not in 3 years, in 4 years. And then she would settle down in Trinidad with the boy, and essentially the mother here was wanting the boy to live with her so the grandmother wanted the grandson to be with her so that she could take care of the grandson. And because of this, she convinced the daughter to move to Trinidad after studying law. But with the change of plans that the daughter has done by remarrying, not completing the course, it seems that the daughter has breached the agreement even before mother could do anything. So please, you may write down the answer as to what you feel is the correct answer. I'll take you through to the answer. So there are two opinions that came. Opinion one said that there was no legally binding agreement because it's a family or a social agreement. And just like in the Balfour versus Balfour case, it was just an arrangement and that it could not be enforced. However, Salmond, on the other hand, said that it was a valid contract. The daughter could not have intended that, or the daughter could not have expected the mother to support the family in perpetuity. Thus, the contract was first broken by the daughter, and the mother was only responding to that contract, to that breach. I'm so sorry. And this opinion, in my view, is the correct opinion with respect to this particular matter. Now, let's go to the different types of contract that exist. So, we have contracts that have been defined under the Act, and then there are some contracts that are understood by way of nomenclature. So, we have void, voidable, express, implied, unlawful contracts. And then, as understood by nomenclature, you have illegal, unenforceable, executory, and executed contracts. I sort of felt we should start with a valid contract defined under Section 2H, where an agreement enforceable by law is a valid contract. A voidable agreement, on the other hand, is an agreement which can be enforced only by one party as against the other. And it can be avoided by only one party, having the power to resign the contract at the exclusion of the other. And this could be primarily because one of the parties has either may have misrepresented. So the party who has misrepresented, because they are in the wrong, they do not have a right to decide whether the agreement should continue or not, but it can only be decided by the party who has been wronged. There are certain times when the parties who have been wronged feel that this was not an important aspect of the agreement. That piece of information was not important part of the agreement, and that they would have entered into an agreement irrespective of that information. So they may want to go ahead with the contract. In that case, it will become part one, that is a valid contract. However, if that party says, no, the information that has been misrepresented is a very, very crucial piece of information, but for that information, they would not have entered into the agreement, then it will become a void agreement. That is, that agreement cannot be enforced by the law because it does not have free consent of the parties. So void agreements are the agreements that cease to be enforceable by law. They are void. They are void ab initio. That means there was no agreement right from the inception, and that there is a complete nullity with respect to that agreement. Under the Indian Contract Act, there are some examples. There are some provisions of law that have been made which say that these agreements, under any circumstances, would be considered as void agreement. Agreement in restraint of marriage, agreement in restraint of trade, agreement against public policy, agreements in restraint of legal proceedings, uncertainty, where the meaning of the agreement or meaning of the terms in the agreement are not clear, and an agreement by way of wager. I will be explaining these terms in future classes. Then we look at what are express agreements. A proposal, an express agreement as per Section 9 is where everything has been written down in express words, communicated to both the parties in express words, and therefore it's an express agreement. Implied agreements, where actions have been taken in order to indicate that I accept your agreement. For example, I tell somebody, I want to buy I'm willing to sell my book to you. And for this, I'm going to charge 100 rupees. The other party does not respond, but they transfer rupees 100 to me. So impliedly, they have accepted the agreement that, okay, for rupees 100, they are willing to buy the book that I'm selling. Understood? So that's an implied agreement. Then a quasi-contract. These are the agreements that are formed on the basis of relationships recognized by the law. So, for example, finder of goods. I find a certain, let's say, a product, a certain scale or something. I am duty bound to ensure that this thing that I have found finds its true owner. That would be a form of quasi-contract. Unlawful agreements. Section 24 mentions unlawful agreements, that an agreement is void if it has unlawful consideration or an unlawful object, which means I want to start a brothel. That's an unlawful agreement. That's not allowed. So it will be a void agreement as defined by nomenclature. So unenforceable contract, a contract which cannot be enforced by the court of law. Illegal contract, sometimes it is used as synonymous with the unlawful agreements, but essentially it means that an agreement enforceable by law but contrary to law. It is inappropriate and it is contrary to the law, and therefore it is an illegal agreement. All illegal agreements essentially would be void, but not all void agreements are illegal. Executory agreements, where all the terms of the agreement have not been completely executed by both the parties. Go back to the newspaper example that I gave. Till such time that the month is complete, it will be a continuous agreement between the customer and the newspaper boy to supply the newspaper every single day. Here, the example that I have taken is booking of a car, even though a huge time lapse exists between booking and receiving the car. So it's a continuous agreement. So it is a executory agreement. Executed contract, on the other hand, is which are completed immediately without a time lag. I go to the shop, I say I want a bottle of water, and I take it immediately. Buying a fridge, having delivered to your house immediately thereafter, that is an executed contract. So, dear students, this is all that I wanted to talk about: the different types of contracts, the different types of agreements that exist, and the definitions of the law of contract, the concept, and the various characteristics that help us understand what a contract is. You need to be able to understand these in order to be able to answer these questions. So the questions that I've framed here are extremely simple. The Indian Contract Act was drafted by Lord Fitzjames Stephen. Then, when was the Indian Contract Act enacted? Here I've given you these dates: 1st September, 1st July, 1st August, 1st January. Then the law of contract, rights in law of contract are rights in rem or rights in personam. Now here you have to be very careful in taking the answer, because rights in re propria, in re alienea, these have not even been discussed till now. Right? What are quasi contracts? Those which are created on the basis of relationships recognized by them. This is something that we've already discussed. Mutuality means what? That's answer B. Equality of rights between the parties. Consensus or item is A, which means meeting of the minds. Voidable agreements can be enforced by any of the parties, cannot be enforced by any of the parties, can be enforced by only one party and not the other. So answer C is a voidable agreement. In the case of McGregor versus McGregor, the court recognized the principle of contractual obligation or liability between husband and wife. So answer A. Contract has been defined under which provision of law? Section 2H. So the correct answer is C. And the law of contract was recognized in which of the following law commissions? First, second, third, fourth. And the answer is C, the third law commission. We will be, in the next session, I will be taking you through the foundations of formation of the contract, where we will talk about the concept of offer, invitation to offer, and the method of communication of the offer in order to ensure that a valid agreement can get created. Thank you so much for your patient listening. Looking forward to receiving your valuable feedback. Thank you so much.